Hi, it's again Sergey Chernik in Berlin Immobilien. Today is September 8th, 2023, and we'll talk about the rent decrease by the tenant. Some of you already had this problem. It's as the tenant approaches you and demands the rent decrease because of this or other defect or fault in the rented apartment. To those who didn't have this problem, I wish not to have it in the future, but let us discuss it. So generally in Germany, the landlord must maintain the apartment in the functioning state. Electricity, heating, water must be uninterrupted. The apartment should maintain heat. And not to contain life-threatening substances, for example, asbestos. It's in general. By the way, I will add description in English to this video where I will list all the information we are talking about in this video. So that was in general. In particular, as you transfer the flat to the tenant, you make a protocol. In this protocol, you fix the state of the flat. And it's actually the state that you owe the flat to the tenant. And the tenant has rights to demand from you to maintain the flat in this state during the whole rental period. Surely the normal wear off of the flat, normal depreciation of the flat should be taken into account. By the way, the lawmakers did not explain what the normal wear off, what normal depreciation are. So it's quite unclear. But you surely rented the flat to human beings and they walk on the floor, they touch the walls, they open the water in the faucets, they open the windows. So surely the flat must wear off with the time. In Germany, there is a law, number 536 BGB, that regulates the rental decreases. By the way, I'm not the lawyer. I don't give you the legal advice. The law doesn't say what exactly the rental decrease should be in which case. There are many tables. For this video, I used one of these tables, and all these tables, hundreds of tables, use the precedental decisions of various German courts. The table as I use also uses many various precedental decisions of German courts. Let's start. The landlord also is responsible for his apartment or her apartment, not for the house, not for the neighborhood, but sometimes there is need to bear the consequences of the decreasing level of the house or of the neighborhood. Nothing to do. It's life. The burden of proving innocence lies primarily on the landlord, not on the tenant. But once the landlord has provided his or her innocence, proofs of his or her innocence, the next one to prove innocence is the tenant. By the way, if there is a defect in the flat, the tenant is obliged to inform the tenant, the landlord. If the tenant does not inform the landlord, there may be, with time, decrease in the value of the apartment, and it occurs incurs the financial losses to the landlord, and in this case, if the defects were not, if the landlord was not informed about the defects in the apartment, the landlord has right to sue and to ask compensation from the tenant. So the tenant must inform the landlord in writing. The tenant must describe the defect, provide the evidence of defect, explain where the defect has long or short-term effect, what problem on his opinion caused the defect, whether on his opinion the fault on the defect is on the side of the neighbor's house, neighborhood, or whoever else. The tenant is entitled to the rental reduction from the moment the landlord has received the written notice about the defect. The tenant is obliged to give to the landlord specific period of time to repair this defect, to eliminate the defect. The tenant also has right for the self-elimination of the defect if it needs to be done immediately. For example, there is no water in the flat, there is no electricity in the flat, there is no heating in winter in the flat, there is flood in the flat. So in this case, the tenant has right immediately take care of the defect himself, herself, and then to coordinate the compensation from the landlord later. The rents can be retroactively compensated. So the tenant has right to continue paying the normal rent and later to be compensated from the landlord. If the tenant has decreased the tenancy fee too much, and it has been proven by the court, the landlord has right immediately stop the rental agreement without special notice. In this case, the rental decrease done voluntarily by the tenant will be considered as not paying in time in full amount, and it brings the situation of the immediate cancelling of the rental agreement. The defect that lasted just a couple of days cannot have effect on the total monthly rental payment. In this case, if the defect was short-term, lasted only a couple of days, it should be recalculated in accordance to the relative part of this day in the full month. And only this amount can be deducted from the total rent. The reduction is being taken normally from the gross warm rent and not from net cold rent. So here are some examples of the rental deductions. For example, in the normal, ordinary, not social flat, the size deviates by more than 10% from the size given in the rental agreement. The rent can be decreased by 1% on every 1 square meter, but only in the case the size of the flat has been deviated by more than 10%. If we're talking about the social apartment, this 1% on every square meter can be calculated from the first square meter. 1% decrease on 1 square meter. The tenant, you can laugh, but this case has also happened. The tenant has not right on the rental decrease if, for example, the heating supply into the flat has been stopped by the fault of the tenant. For example, the tenant has electricity agreement with the electrical company and did not pay. The electricity supply was stopped. So in this case, the tenant has no right to demand decrease in the rental fee. If the defects are only in special rooms of the apartment, there is no right to decrease the whole rent. There is need to recalculate the weight of the special room into in the whole size of the flat or whole importance of the flat. For example, if we're talking about living room, it's 28% of the whole price. Study room, 20% of the whole price. Bedroom, 12%. Kitchen, 10%. Bathroom, 10%. Pantry, 7%. Guest toilet or toilet, 3%. Balcony, 10%. But once again, it's not law, it's precedental decisions of various courts in Germany. In the case of water intrusion into a commercial space and impossibility to continue working in the commercial space, shop, office or whatever, the rent can be decreased by 40%. If there are visible to an eye damages in the ceiling and walls of the living room or bedroom, and this water penetration leads to decrease in the value of the apartment, the rental fee can be decreased by 25%. If there is water dripping from ceiling or walls that damages the flooring, the rental fee can be decreased by 30 to 50%. If there are only water stains on ceiling or walls, the rental fee can be decreased only by maximum of 2%. If there is mold and moisture in the kitchen or in the rooms, 20% decrease. If there is significant moisture or after replacing the windows by newer windows, and there were no informing the tenant about the possible moisture generating, the tenant can decrease the rent by 42%. If there are moisture and mold due to cracks in the walls, the rent can be decreased by 30%. If there is strong humidity in the kitchen, living rooms and bedrooms, musty smell and mold, the tenancy fee can be decreased by 80%, up to 80%. If the flat loses heat by more than 60%, the rental fee can be decreased by 10 to 15%. If there are faulty thermostats on the heating bodies, the rental fee can be decreased by only 8%. If there is failure in the heating in the cold days of summer, let's say temperatures outside are not more than 17 degrees, the rental fee can be decreased by 50%. If it's in winter, the tenancy fee can be decreased by up to 100%. If there is heating in the flat, but it's not significant, it's not enough, it's not sufficient, up to 15% in the flat, up to 15 degrees in the flat, the rental fee can be decreased by 25%. If there is a construction noise from repair works in neighboring building, the rental fee can be decreased by 20%. Yes, the landlord in this case is not faulty, but nothing to do. If there is noise and dust from the demolition or building a building on the neighboring land plot, the rental fee can be decreased by up to 6%. If there is a construction site, noisy construction site on the neighboring land plot that works also at night sometimes, the rental fee can be decreased by up to 12%. If there are hammer works in your building, the rental fee can be decreased up to 10%. That's it for today. Stay with us, give us your likes, share this news, subscribe to our channel, leave your comments. Thank you very much. Trugečernik Berlin Immobilien. Bye.